Joining us now, Chuck Rosenberg, former U.S. attorney and former senior FBI official, Catherine Christian, former assistant district attorney at the Manhattan DA's office, MSNBC legal correspondent Lisa Rubin, and Charles Coleman, civil rights attorney and former Brooklyn, New York prosecutor. Also with us today, Misty Maris, a defense attorney. Great to have all of you here with us, and let's get right to what happened in that courtroom.
Lisa,
you were inside.
That's exactly right.
I was, and I'm really grateful that Judge Merchan allowed people to hear his voice, in large part because I heard that voice every day for 7 weeks, and I'm glad that the American public can now hear what we heard. Judge Merchan was today, as he was during the trial, calm and measured, never nasty, always wishing criminal defendant Trump well, including at the very end here, where he said, "Sir, I wish you Godspeed as you assume your second term of office." But the thing that I found most remarkable, Anna, was that while Merchan was not changed, Trump and Blanche were slightly different than they've been lately in their papers, and certainly than they were during the trial.
How so?
They were forceful in their response to the imposition of the sentence, to the very existence of this case. And while they attacked Alvin Bragg by name, not by name, another participant in the prosecution team who came from the Department of Justice, you heard Trump sort of pointing at him, this man here, right? The one person they didn't attack is Juan Merchan, because they understand now that Chief Justice Roberts is watching. Judge Merchan quoted Chief Justice Roberts back to them in his opinion last week, saying, look, the chief and I are in agreement. The kind of rhetoric that you and your lawyers used throughout this trial, it is a danger to the rule of law being upheld in this country. It is a danger to our democracy. And as you increasingly appealed or pursued your legal rights, even when it was clear that you had no leg to stand on, your rhetoric got sharper and sharper in a way that I find objectionable, and therefore I'm going to put in this long footnote in that opinion indicating as much. And then you see today the DA's office, Josh Steinglass, reminding Judge Merchan again of those dangers that came into Chief Justice Roberts' report. I thought that Trump, particularly given the Supreme Court's ruling last night, 5-4 with Roberts with the majority, is a little bit chastened by that.
Yeah, and Catherine, at the time that the president-elect was speaking, he was still under the gag order, a gag order that is no longer existent after the case gets concluded. But it seemed like it was a quick, fast process. It's pro forma in so many ways, in such an unusual case.
Well, remember, in this case, we knew what the sentence was going to be. So this wasn't a case of the prosecutors asking for a specific sentence and the defense saying, no, that's too much time. Everyone knew going in it was going to be an unconditional discharge. Also, in New York State, at least in that courthouse, sentencing proceedings really don't last longer than 30 minutes, depending on the facts of the case. It moves pretty. So I agree. This was an incoming president of the United States. You thought it might be a little, maybe an hour, but really, everyone knew the sentence. So there was, and Judge Merchan put everything he needed to say in his decision last week, and he even mentioned that he wrote about what he was going to say and doesn't need to do that again.
Chuck, we heard Judge Merchan say the only lawful sentence without encroaching on the highest office of the land is unconditional discharge. What do you make of that?
Well, I think he's right, Anna, in the following sense. Most sentences, almost every other sentence I've ever seen, certainly in my time as a federal prosecutor, carries some penalty, right? So if not incarceration, a fine or restitution or supervised release or probation, all those things potentially could extend into Mr. Trump's presidency. And so what Judge Merchan was trying to do, and did it effectively, and we can talk about the strategy, is make it clear that there would be no penalty. There would be an entry of judgment today, and the trial is over. There's no tail on this case in terms of encroachment on the duties of the office of president. And that resonated with the Supreme Court. If you look at what they did last night, that was important. They cited two factors in permitting this sentence to go forward. One of them was that Mr. Trump would be able to appeal, of course, as any defendant can, once entry of judgment was made.
Because it had to get through sentencing for the case to be complete and the conviction to be like stamped, essentially, right?
Exactly. It had to be stamped. The second reason the Supreme Court offered was, right to your question, Anna, that there was no additional burden, no lingering burden on Mr. Trump, that what was happening today, what happened today, was discreet and it's over. And so the presidency is not burdened. And that obviously resonated not just with the so-called liberal justices, but also with Chief Justice Roberts and with Justice Amy Coney Barrett. That was important to them. And because there were 5 votes to let the sentencing proceed today, the sentencing proceeded today.
Charles, and just your thoughts on unconditional discharge being used in felony cases, and then also, at times Trump often talked about the fact that this was a political witch hunt, that there's a political aspect to all this. He actually mentioned it in his remarks right before he was sentenced. What do you make of all this?
I'm a former prosecutor. Chuck's a former prosecutor. Catherine's a former prosecutor. Lisa has been around the law. Has been around the law, but as 3 out of 4 former prosecutors can tell you, you go where the facts take you, and you prosecute on the basis of the law. Alvin Bragg had a job to do. Jack Smith has had a job to do. That is a different conversation because of how the federal government goes about in their rules with respect to prosecuting sitting presidents. But Alvin Bragg did what he was supposed to do, and he got a conviction. For millions of Americans, Jose, the idea of being saddled with a felony conviction can be a huge and tremendous obstacle. Not only because of the penalties that are imposed, but just the label itself. Yeah. It is very jarring to see and to feel and to watch someone, when we've been saying literally for years, decades even, that no man is above the law in the United States of America, because that's how our system works. To watch someone essentially walk out of court a free man with the same label that will prohibit some other people from finding housing, from getting jobs,
traveling,
from being able to travel and live from being able to vote, even though he will have his right to vote taken away in Florida, from being able to live a normal life. And so for me, I am thinking very much so, number one, about the historic nature of today and how significant it is. And then also, number two, this does unquestionably reinforce the notion of there being a 2-tier justice system in the United States.
Misty Maris is our defense attorney of the group. I want to get her in here because you point out the folks at this table right now have prosecutorial experience. Misty, do you see what happened today through a different lens? What are your thoughts?
Well, Anna, here in this particular case, there's a question about what was possible under the law. What was a sentence that could have been handed down with this particular Class E felony? But that's versus what is practicable. And from the perspective of what is actually practicable, this was truly the only way to get this case to finality, for there to be a sentence imposed, and for the will of the jury who did convict, who found Donald Trump guilty, to actually have him move forward through the criminal justice system in the way that any other citizen would. So is it unusual to have an unconditional discharge for any felony conviction in New York? Absolutely, incredibly unusual. But in this particular case, it was truly the only option to actually complete this case, have it stamped, have it done, and have that judgment of conviction be finalized.
And so, Chuck, now, and, Blanche said it, first words out of the gate, we're going to appeal this, and we're going to appeal every single word of this. How do you see an appeal going, and what are the steps going forward?
Yeah, Catherine and I were talking about this before we came on the set. I think there are some difficult issues for the government in an appeal. Remember, Judge Merchan tried this case, and I agree with Lisa, tried it well and professionally before the immunity decision came down from the Supreme Court. So the ground shifted under the feet of the prosecutors and the judge and the defense attorneys after the trial. And one of the things we learned from the Supreme Court is that the government ought to be staying away from executive branch witnesses, at least arguably so, Jose. The government, however, backing up a bit, called 2 White House employees, 2 executive branch officials, Madeleine Westerhut and Hope Hicks, as witnesses in the criminal trial. I'm not sure they would have done that had they known about the immunity decision, which was to come. So, did the government accidentally, initially, make a mistake that is, that might, on appeal, lead to a reversal of the conviction? I think that's a real possibility. I don't think it's definitive. I don't know that that's what will happen. But if your question is, does Mr. Trump have something that he can credibly argue on appeal to seek reversal? The answer is yes, not because Judge Merchan made any mistakes. In fact, the prosecutors, as far as I can tell, didn't make any significant mistakes, but the land shifted under their feet with the immunity decision.